pain medications. I want to state for the record that I'm a duly licensed physician in the state of Michigan. My job is to treat patients that have legitimate pain, have legitimate illnesses, and that's what I have done. I have a well-known pain protocol that clearly states to all my patients that they will receive no pain narcotics or medications unless they can show documentation first. Before I even examine them, before I evaluate them, they must go get the documentation from the hospitals or from the diagnostic center showing that they have severe abnormalities that would warrant that they have chronic pain that needs to be treated with narcotic medications. That's my job. I took a Hippocratic oath when I came out of medical school that I would treat patients with illness and that I would do no harm, and that if pain medication was needed, that I'm licensed by the state of Michigan to do so. This raid, okay, that took place on December 4th of 2008 ultimately resulted from a case that occurred originally in 2001, where 3 black doctors, including myself, was charged with criminal activity by the state attorney general, at that time Jennifer Granholm. They alleged that we had indulged ourselves in criminal enterprise and Medicaid fraud, and that we had aided and abetted the unlicensed practice of medicine. They charged us with this crime after a 10-month investigation, or when they had all the evidence that we were not involved in any criminal activity, and essentially we were framed with this type of criminal conduct. The 3 doctors stood up and fought against the state attorney general and the Michigan State Police, and we all won our case. We walked away. After that, I filed a $50 million lawsuit because the proceedings of them trying to frame the 3 doctors with criminal activity, I was tied up in the case for approximately 6 years, and I lost my practice, had to declare bankruptcy, my health failed, and now I'm so severely ill I'm not able to work very much to support my family. So I filed a $50 million lawsuit in federal court, okay, alleging that they knew that we were all innocent of any crimes, but they charged us anyway. And then after the preliminary exam, when the case within the preliminary exam crumbled, then they resorted to witness tampering, and they told witnesses what to say to get a fraudulent conviction against us. But the witness went on the witness stand, and he clearly stated that he had never met with me, he had never talked with me, and so that I couldn't have been involved in the conspiracy. And he also indicated that he didn't know what the terminology of a kickback was. And so my lawyer asked him at that time, well, what if you don't know what a kickback was, who gave you these type of terms to get up here and testify to? Was it the prosecutor? Was it the investigator? And he said it was. And that was clear witness tampering, which is a federal felony. It's a violation of U.S. Code Title 18, Section 1512. And it mandates that the state attorney general, who was at that time Jennifer Granholm, who passed it over to Mike Cox, they had to report this to the feds, the federal government, because the federal government would have investigated this and people probably would have went to jail. But they covered this up. They also covered up the sexual assault of a 15-year-old then African-American female who was sexually assaulted by their key witness. They did not charge their key witness with this crime, but they covered it up and then coerced his testimony so that he would get on the stand and give false testimony in order to get fraudulent convictions against 3 innocent doctors. We all stood up, we fought, and I did my own investigation and came up with all of the documents contained in this folder here. And then when the judge found out, when they compelled the discovery and found out what I had, the judge did not want all of this to go to trial because it would have exposed the corruption. So what he did was he granted a nulli prosequi, and it was for the purposes of active concealment of criminal activity. And so he dismissed the case. But it was to cover the judge in the case, the prosecutors and the investigators who had engaged in the criminal conspiracy of witness tampering, which is against federal law. And so this is what the case was about. So after I filed the $50 million lawsuit, I was given a hearing in federal court downtown Detroit with the Honorable Arthur J. Tarnow residing as the federal judge. When I went to that hearing, there were 5 attorneys for all the listed defendants, including Mike Cox, Jennifer Granholm, David Edick, who was the assistant prosecuting attorney, George Stevenson, Mike Larson of the Michigan State Police, Scott Van Treese of the Inspector General's office, who is a federal officer, who also went to the prison at the time and coerced the witness testimony, okay, of Mr. Clarence Jones to testify fraudulently under oath. After all of this happened, okay, and I got the evidence within the transcripts where the key witness said that he never met with me, that he sent someone to get my approval. Well, if he sent someone to get my approval, I couldn't have been involved with the conspiracy. The person he sent to get my approval never came back to tell him that it was okay for him to use my name and the other doctor's name, but he used their names. So once all of this evidence came forward, the judge in the case, who was also defendant in the $50 million lawsuit, he gave a nulli prosequi and dismissed the case. Well, a nulli prosequi is just a legal proceeding saying that the prosecution quit their prosecution. They abandoned the prosecution after holding me under siege for nearly 6 years. The nulli prosequi in of itself says it's a presumption of correctness from the judge that this case was flawed, that I was innocent, that they couldn't meet their burden of proof. But they held me in the case and destroyed my practice and everything I had for approximately 6 years. And so that was the basis of my lawsuit, okay? And then so this raid was a high-ranking official, one or more of them, calling in a favor from law enforcement, okay? The hitting agenda was to come in and to raid the premises with the intended purpose of stealing the documents or the evidence that proved that they had violated the law. They had violated federal law, okay? And so if they came in to steal the evidence, then I would not be able to proceed with my lawsuit in federal court, okay? Now, the judge in the federal court, in open court, stated, and we have witnesses that's in this room, that was in the courtroom, when the judge said that he did not read my complaint, and he said that I had over 100 exhibits, and that he's asking questions now because he didn't read it. And my question was, if you didn't read my complaint, how could you fairly adjudicate and then grant all of these high-ranking officials a summary judgment and throw my case out? If you didn't read my complaint, you can't fairly judge to give them a dismissal. Judge did this, okay? And so what I did was I filed an appeal in the Sixth Circuit Court, the United States Court of Appeals in Cincinnati. And they opened the docket immediately and granted me an appeal. And then this is when they came in and they had to get that evidence, because if they didn't get this evidence, this would prove that they broke the law, violated the Constitution of the United States, tried to frame 3 doctors, and they covered up the sexual assault of African-American female to increase the credibility of their star witness. He was already, and I have the documents to prove it, a sexual offender. They knew it when they covered up the felony that he did a pelvic exam on a 15-year-old girl and he wasn't licensed to do it. That's a sexual assault because he penetrated this girl's vagina. They covered up all of that evidence, okay? And he was never charged with the crime. So as a result, they ordered this raid. This is a favor that a high-ranking physician, one or more, could have been the judge, could have been Jennifer Granholm, could have been Mike Cox, could have been the state police. But they asked the Genesee County Sheriff's Department to do them a favor to get this evidence out of my house and out of my possession. Because this is the only way that they could beat me in terms of a lawsuit. By doing so, they deprive